All right, this is case number 22140039. This is Blaze Medical Solutions LLC versus City of Detroit. The matter is before the court, set on for an adjourned pretrial conference, I believe, in regard to this matter. Your appearance at this time for the plaintiff, please.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing in place of attorney for plaintiff.
All right, you kind of broke up at the end. You're appearing for who, Mr. Saloom?
The attorney of record, Elias Mawad.
All right, thank you. Thank you, counsel. For the City of Detroit, your appearance at this time, please.
Yes, Patricia Porter, P66989 for the City of Detroit.
All right, thank you, Ms. Porter, and good morning to you.
Morning.
I do see, I previously set out a scheduling order and then set this over for today's date as a pretrial conference. So go ahead, Ms. Porter. I think you'll be the best person to update me on the status of things here, please.
Yes, we did serve discovery and I received plaintiff's answers today and they were timely filed today. And I would like to request a short extension of discovery for 30 days or an extension of time to file a motion, because through that discovery, it appears that their only date of service was more than a year before they filed the complaint. So I'd like some time to file a motion for summary disposition on the 1 year back rule.
Mr. Salam, anything you wanted to bring to the court's attention at this time, sir?
Your Honor, I'll leave it up to the court's discretion whether to allow the period of time. I think discovery ends today, but I'll leave it up to the court to make that determination.
Yeah, obviously, if there's a dispositive issue that has arisen by virtue of the discovery, or if a bit more discovery is needed to see whether or not that issue could be vetted out, then that makes sense. So, counsel, I'll go ahead and extend the order on discovery for a period of 30 days and set this over for July the 7th. Let's go ahead and do it again, July the 7th. And the same rules will apply that are currently existing under the order for discovery. And specifically in provision number 6, it does allow for the filing of motions to be heard on the next action date, that is the 7th of July, so long as the plaintiff or the other party receives at least 10 days notice prior to the hearing date. So you can file your motion. You also have opportunity to vet it out or to look deeper into any discovery issues during that period of time. And that date will be set for an adjourned pretrial conference day out hearing the motion that is filed under the rules as set forth in the court scheduling order. That scheduling order has already been disseminated. It is dated April 7, 2022. It's extended for the 30 days as indicated. All right, I do wish both sides well. I'll see you on the next action date. Good day to the two of you.
Thank you, Your Honor.
Yeah. Okay, yeah, I wrote it down.
The court now calls case number 21-168-794. This is Velocity Investments LLC versus Geraldine Stevenson. The matter is before the court, set on today's date for a motion hearing. This is relative to a complaint that alleges damages in the amount of approximately $3,500. There was a petition for entry of judgment by default. The court set the matter over until today's date on the plaintiff's motion for summary disposition. Your appearance for the plaintiff in regard to this matter, please.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
Thank you, Mr. Brown. Thank you, Mr. Johnson, and good morning to you, sir. I am now looking for Geraldine Stevenson. If you're on the Zoom, ma'am, please say something at this time.
I'm here, Your Honor.
All right. Thank you, Ms. Stevenson, and good morning to you as well, ma'am. I have received the motion for summary disposition. It is, of course, set for hearing on today's date. I do not see where there has been the filing of any written response to that. Did you get a chance to put in any written response to that motion, Ms. Stevenson?
I didn't know I was supposed to do anything.
All right, you received something in writing, you received that motion in writing. My specific question is whether or not you filed an answer or written answer to it. The answer to that sounds like no.
Yes, that's no, because I didn't know what to
All
do.
right. Gotcha, ma'am, but you understand what's being raised in the motion, is that correct, ma'am?
And I really don't understand the paperwork. He told me, well, we spoke on the phone, but like I was saying, I have memory problems, so I don't remember everything that we spoke about. But we did speak after court last time.
Yes. All right, I do remember that. And it seems that there was some effort to reach some resolution in this matter, and the parties have not been able to do so. And counsel has submitted a motion for the court to decide this on legal issues at this time. You may proceed at this time, Mr. Johnson, regarding this matter, sir.
Okay, thank you, Your Honor. Just briefly, Your Honor, this is simple credit card case. You know, I don't think there's any genuine issue of material fact under MCR 2.116 C10 that Ms. Stevenson took the credit card out, that she made payments, that she made charges on the credit card, that she went into default, that the credit card debt was sold and assigned to my client, Velocity Investments LLC. And as stated in the motion, Ms. Stevenson doesn't have any standing to challenge that assignment. Every time I've talked to Ms. Stevenson, obviously she has memory problems. I understand that, but she just claims she has an inability to pay, which I understand, but still that doesn't absolve her from liability or a judgment. And that's all I have.
All right, thank you, Mr. Johnson. Now, Ms. Stevenson, anything you have to say in that regard? I know that one of the things that you mentioned the last time, and this has come up, I believe, a few times, that this is a situation where you do not have the
Card out. I did pay. I paid on it regularly, and I had a car accident,
Yes.
and I worked since that car accident. And I get $674 Social Security a month, and that's all I get.
Yes, ma'am.
But before when I made my last payment, when I got my last check, I did call them. I did close the account so it wouldn't occur anymore. I closed the account. I explained to them what was going on, and I made the last payment, and it went up under the so I wouldn't owe no more. I mean, you know, so I don't even know.
No charges or anything like that. That's what you're saying to me?
Yes.
Okay.
And I just don't have anything.
Yes, ma'am.
If I had it, I would have paid it like I paid it from the time that I had it.
Yes, ma'am. All right, ma'am. Thank you, Ms. Stevenson. I listened to the argument on the motion for summary disposition and in response thereto. The motion, of course, is brought pursuant to MCR 2.116 C10, motion that alleges that there is no genuine issue of material fact, even when the evidence is viewed in a light most favorable to the non-movement in this matter. If I take all of the differences and aim them in favor of Ms. Stevenson, I still can't find a genuine issue of material fact. The argument and dispute here has to do with payment and how to make payment and whether or not the defendant has any ability to make payment. Those issues are not central to the underlying issue of whether or not there is an obligation, whether or not there is an indebtedness. For that reason, I will grant the motion for summary disposition, finding that there is no genuine issue of material fact, and the court will grant the motion for summary disposition and will enter judgment on that motion. Ms. Stevenson has indicated several times that she doesn't have ability to pay, doesn't have resources, and that she receives a federal benefit. Well, of course, that federal benefit is not collectible, and she always has a right to pay on the judgment if she desires to do so. She also, if she wishes, she can file a motion or petition before the court asking for the right to make partial payments. But the issue of whether or not the plaintiff has the right to judgment on this assigned debt, at this point, there's really not a defense to the claim. And therefore, the court will enter the judgment at this time. And that will conclude matters regarding this case. I do wish both sides well, and you'll receive a copy of my order granting the motion for summary disposition and entering judgment regarding this matter. The total judgment amount is $3,506.63. It is so ordered at this time. Good day to both sides.
Thank you, Your Honor. Good day to you as well.
The court calls case number 15-123-233. This is American Road Services Company versus Kathy Reyes Velez. The matter is before the court set on for a pretrial conference. I specifically remember receiving a stipulated order for adjournment previously. I thought that this case was resolved, but maybe I'm mixing it up with something else. Your appearance for the plaintiff.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff P number 74809.
All right, thank you, Ms. Williams. Good morning to you, ma'am. For the defendant in this matter, please.
Mark Linton, P66503 for the defendant.
Thank you, Mr. Linton, and good morning to you as well, to both of you. Somebody update the, Ms. Williams, I think you came into this a little later, like the last time that we were here was your first appearance in this matter. Is that correct? My memory serves me right.
No, I think I've been involved in it since the entirety, but I think the court is referring to, the court indicated that you thought the issue was resolved. That is a proper recollection because the last time we were here, my client was reviewing it to make a determination if they were going to dismiss the defendant voluntarily. I still do not have authority to do that as I sit here today. So I do not have a report to update the court as far as if we can dismiss the defendant voluntarily.
All right, okay, that's what I'm recalling then somewhat faintly, that there was a thought that this might be headed towards that type of resolution. So where do we need to go in relationship to this? What is your pleasure, Ms. Williams, and then I'll come to you, Mr. Lynn.
Your Honor, if the court is inclined, we've completed discovery. If we could have just one more final pretrial conference before actually setting a trial date. Again, I can't say what my client is going to do, but given that final pretrial date right before a hard trial date may get the ball moving on whatever their decision is going to be.
All right, if I'm recalling now, this case too has something to do with a defendant who might have been under some distress secondary to some abusive situation. Is that this case?
That is correct, Your Honor. That was, and I don't know if the defense want to speak to that. That is the proper case, Your Honor. There was that issue that was brought to the court's attention and also brought to plaintiff's attention as to the defendant needing the default set aside because there was some issues that was going on in a domestic relationship.
Okay, got it. Mr. Lynn, anything you want to weigh in on, sir, at this time?
I guess if the court's willing to provide us additional time, hopefully Ms. Williams would receive authority to dismiss from her client and we could resolve the matter that way. But obviously I know the court wants to keep cases moving, so whatever you would like to do.
Yeah, it seems to me that some of the special circumstances here may give rise to the need to ponder this a little bit more. We think the case is moving, but I try to be. I certainly got to be sensitive to the possibility that some other nuances may impact how this case should be dealt with. So we'll proceed in that manner, and I'll set it over for a final pretrial conference date. So not the 7th of July.
Yeah, because that's too. Oh, well, actually, that week you have, July the 20th.
July 20th is the date that I can give you, July 20th.
It's good for plaintiff.
All right, thank you. 9:45 a.m. July 20th, 9:45 a.m.
Very good. Okay, thank you.
Thank you. Good day to the two of you.
Thank you, Your Honor. Good day to you too. Take care. Mr. Wilson.
Court on the record finds good for adjournment of the pretrial date as the court now calls case number 21-341-547. This is Motor City Corporation versus King's Customs Incorporated. The matter is before the court on a motion for a new hearing or for rescission with regard to what the parties apparently agreed to. This case seemed to have been resolved previously. The court went ahead and set it for a hearing on the basis of a motion that was recently submitted to you. Your appearance for Motor City Corporation on this film?
Good morning, Judge. May it please this honorable court, Lance Mason, P43926, appearing on behalf of the plaintiff, the moving party in this case, Judge.
Thank you, Mr. Mason, and good morning to you, sir. King's Customs Incorporated, if you're on the Zoom, someone say something at this time.
I'm on the Zoom, sir. I do not see my attorney in here. I have not been able to reach him this morning.
What's your name, sir?
Lynn Kirkpatrick.
All right, thank you, Mr. Kirkpatrick. Counsel, what's going on here, Mr. Lance? Looks like
Yes, Judge. As you recall, basically what happened is that there was a consent judgment entered on the record in this case, Judge. Subsequently, I submitted an order under the 7-day rule. The court ruled that I could submit an order under the 7-day rule. I submitted the order, but respectfully, the court inadvertently entered the order before the 7 days were up. Defendant, Mr. Applebaum, did object to it. I presented a new order attached to my pleading to see whether or not that should resolve the issue. I talked to Mr. Applebaum yesterday. I assume that he's aware of the hearing date and that I'm just trying to get the order resolved because get the order language in the order resolved. I submitted a proposed order. The previous order was submitted in error in terms of he objected to it. I presented an order. We had some conversation, so I'm not sure where all of his objections are to it at this point. He's aware of the hearing date because I made a phone call to him yesterday. So I'm just trying to get some understanding as to why he's not here. I can make a phone call to his office, but I'm just trying to get it clarified today, Judge, because it's been so much time pending in this case.
Yeah, it's been back and forth a little bit. So the order that you submitted, the subsequent order that you submitted it under 7-day.
Right. The previous order I submitted back on May the 2nd under 7 days, but because technically it was signed before that was up, I just want to procedurally follow. So I submitted a subsequent order to clean up any issues in the previous order. And what I have before you is my proposed order. But I thought, I'm a little surprised Ms. Applebaum was not here because we talked yesterday, so I'm not sure if something is wrong. But I'd like to at least make a phone call, but it's been a lot of delay in the case, Judge. I'm just trying to move it forward.
Got it, and understood. All right, so why don't you go ahead and make your call. Mr. Applebaum he's like yourself. You show up for your hearings, and so it's a good thing. I know him, I know you. I know that you guys practice. I know what kind of law you guys practice. So
correct.
His not being here will not affect this one way or the other. The worst case scenario would be about set it over for next week, and we'll come back and try to hash all this out. We'll see if you can reach him now.
Thanks, Judge. I'm gonna go on mute and step away from my desk and give him a phone call.
Yes, sir. All right.
Thank you, sir.
Thank you. So we.
We're not, I'm not. The files are there, so she's gonna do it.
Correct.
So they want us to
Let's
know.
go. I need to know what's her call time.
Okay, okay. Yeah. So you can be here, that's her first week. So I guess you have to call.
Maybe just
So I think you'll go back, you go, because I wrote it down, I think you'll go back on there for next week. We won't do it again until August. Unless
Well,
they
they
swap
probably
it, they
will.
probably did swap
Yeah,
it.
they're gonna swap it.
Yeah. Yeah, because I was thinking about her file. I think they said the file was for. Yes, her clerk is
So
gonna
that's
say.
okay. I'll go on.
Oh, you're still doing it? Okay, all right.
I'll just go there and sign.
Yes, I'll ask her, what we ask her. Clerk, we do she do,
Yeah, what time?
Okay,
I can see how.
all right. Yes, it's supposed to stop it. That's what it said in August, but I don't know. It said if it continues to go, I think it's time.
Yeah, I mean, you know, what's gonna happen, so. I'll talk to you.
Okay, okay,
Well, that's what.
okay, all right. Okay. No, it's a lot, but I mean, move rather quickly, so we'll be able to go down there and then come back.
Yeah, you know, because our situation is so.
Mhm.
it won't be-
That's it. Yeah.
It's,
Yeah. Word.
But I'm just glad that that's not.
Mhm.
You know what I'm saying?
Yeah, 'cause I was like, hey,
And
boy,
that-
yeah, we was really that probably looking at that good. That's a lot. Yeah,
For sure. I'm glad.
yeah. But I still see her. You know that. You can say that. And you may, I said, we know.
I know, it's a good thing.
Yeah.
This could be-
Even though, help, you know how to get it if I'm not here, get everything.
Mr. Lance, sir?
Judge,
Yes, sir. Were you able to get?
that's okay, Judge. I wasn't sure it was on. I called Mr. Applebaugh. He's actually calling the court right now.
Okay.
Thanks for your patience, Judge.
Not a problem. So we are on the record relative to the suffix 1547 Motor City Corporation versus King's Customs Incorporated. Mr. Lance Mason has in fact entered his appearance for Motor City. Your appearance now for King's Customs. Please. Mr. Applebaum, you here?
Yeah, I'm having a little trouble hearing you, Judge. Alan Applebaum on behalf of the defendant.
P number for the record, if you will, sir.
I'm old, Judge. P36444.
Well, don't say old because mine is there at 39, so that's somewhere near it. That's somewhere in your same neighborhood. So let's not talk about old, The old people that have those 1-9P numbers, them the old people. All right.
The old-
Anyway. Good morning. Good morning to you. All right. I understand that there are some difficulties that have arisen with the order of resolution with regard to the matter that's before me. I may have jumped the gun, I understand, and signed a previous 7-day submission before the expiration of the 7 days. In that there is a subsequent submission that is before the court at this time. All right. Tell me about what's going on here, Mr. Mason.
Yes, Judge, the judge recitation is pretty accurate. What I did is I submitted a proposed subsequent order that I believe capsulizes the resolution of this case. I asked the counsel if he had any objections to it, and if anything issues, we need to deal with it right now so we can have respectfully, so we can have an order entered. And so I can pass the baton to Mr. Appleball at this point.
Judge, I have no problems with the order at his exhibit in his current motion at bar. The main thing is I need to make sure that whatever day you sign that order, hopefully today, that you put in the 10 days in the blank so that my client, in theory, would have the right to either file a motion for new trial or an appeal within the 10-day period. And even though I know the date of the writ is passed, my client still has a legal right to file any either a motion, whatever motion, post trial motion or post settlement motion that's allowed under the court rules or an appeal. So as long as he's got that right, then I'm satisfied that the order complies with the agreement we made on the record back in October.
And Judge, to clarify that, I also put in that proposed order on the second sheet, there's the date in terms of the 10-day date that respectfully needs to be put in the order. And hopefully it's today's date to show that the 10 days runs from today's date, June the 9th.
Right. I do see that as provision number 9 in your proposed order. Is that correct?
Yeah. So
Correct.
if you sign it today, Judge, you'd put June 20 in that blank portion.
Yeah, you jumped ahead of me, Mr. Applebon. You're right.
Because 10 days from now is the weekend.
Yeah. You're absolutely right. Nailed it. All right. So I will insert that particular date. And I also see the order rescinding and substitute. So I'll sign the order rescinding, and then I'll sign the judgment of possession after land contract forfeiture with the insertion of June 20th, 2022 as the appeal cutoff date.
Great. And then if I could get that email, Judge, so I can at least get it to my client so that he's got the full 10 days, that'd be great.
All right, very well. So if you will, Counsel, if you will chat your email address, I'll have my clerk to send that to you right away.
Terrific. I will do that.
Right, I'm signing the order now, the orders now, and you'll get both of them out today. And Mr. Mason, if you wanted us to email the order out to you, then just chat your email address, and we'll make that happen.
Thank you, Your Honor.
Now, let me, one other thing where there was a blank, is as a money judgment for damages is awarded in the amount of.
No, that should stay blank, Your Honor. There is no money damages. That stays blank.
Correct.
Mr. Mason?
Correct, Your Honor.
All right, very well. I've covered that part of it, and I believe that everything is a go. And I wish all sides well. You receive copies of this order shortly. Email, or if you haven't submitted an email, you'll get it in the mail. All right. All right. Good day to you.
Thank you, Your Honor. Thanks, Counsel.
Yeah, and I just chatted it in, Judge.
I'm going to chat right now. So thank you, Judge.
Yes, sir.
Okay. Thanks, everyone.
Thank you. Good day.